Court is calling 2023 CR 8806, State of Texas versus Christopher Scott Jones. Can I have parties announced for the record for the state?
Zach Dunn for the state, Your Honor.
Defense?
David McLean for the defense.
And are you Christopher Scott Jones?
Sure.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Christopher Scott Jones who was placed on deferred adjudication in 2023 CR 8806 for the offense of assault, family second offense on November 28, 2023 for a period of 6 years? Is that you?
Yes, ma'am.
State?
Your Honor, about the 21st day of March 2024, Ventura County, Texas, the defendant, Christopher Scott Jones, did then and there contact Scarlett Jones in person in violation of condition.
Okay, pause. This is a huge moment. When the judge reads a violation like this, especially in a family violence case, the defendant's response basically decides his fate. A true plea here isn't just admitting the contact. It opens the door to full adjudication and up to 10 years in prison. If you were in his shoes, would you admit it? Let me know in the comments. Would you say true or roll the dice on not true?
How do you plead to that? True or not true?
True.
And then, Your Honor, the state will waive and abandon the others.
Any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 19, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to a $10,000 fine? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 19? Court will find violation of condition number 19 true. The court will let both parties know. The court has received these documents in the court's file. I have not read them because I don't read anything until both parties have had a chance to view them and have any objections to them.
Absolutely, Your Honor.
So have you all both had a chance to review the documents that are sent to the court's file?
I have not, Your Honor.
Those are the ones from last year.
Okay, those are the ones we talked about last time.
That's exactly right. Yeah, there's nothing new. Those are from nothing from the past week or two, correct, Your Honor? Those
No.
No. So yes, I believe counsel and I have reviewed them in depth, all of them together.
All right. And would you like the court to read these, counsel, or do you have objections?
Essentially, Judge, they're hearsay, but I know the court can consider that.
Well, I mean, if you all have objections to it, then I won't read them. They are hearsay.
I'd object, Judge.
All right. All right. So if the witnesses are not here for the court to read those, then the objection will be sustained.
Thank you.
All right. So is there a proposed agreement?
There is, Judge.
And what is the proposed agreement?
The proposed agreement, Your Honor, is for amending conditions for zero tolerance, house arrest for 30 days, GPS for the remainder of his term, extension for 1 year, and enroll in VIP within 15 days of release.
All right. And who is Scarlett Jones, and why is he contacting Scarlett Jones?
I can get a relationship chart for you, Your Honor. It's a little bit complicated within the...
Everyone, please whisper.
I can get you an answer, Judge. It's in the file. We literally had to draw this out across a couple of cases, Your Honor. Off the top of my head, I don't know, but I can get that information for you in the state's file.
All right. Is it Scarlett Jones or Sydney Jones?
It's, I believe, Sydney Scarlett Jones.
Okay.
Same person, Judge.
All right. Same person. So I ordered.
No, Scarlett Jones is my wife, Ruby.
Okay. Scarlett Jones is Mr. Jones' wife.
All right. And who is Sydney Jones?
My daughter.
All right. And Scarlett Jones. Okay. The court ordered no.
Too well, the judge is not having it. Notice how she keeps returning to the no contact order. Judges take these extremely seriously in domestic cases because they're tied to safety. When she says, "Why are my orders being violated?" That's judicial code for somebody to explain to me why I shouldn't max this man out. This is where the defense has to shift from excuses to strategy. Do you think emotional struggle is a valid explanation here? Comment below. I'm curious what side you're on.
With Scarlett Jones and Sydney Jones.
And Your Honor, may I ask a quick question? The council may know.
Yes.
Ruby, who's that?
No, Scarlett Jones is the person he pled true to the number 19 violation,
Yes.
and I ordered no contact with that person. So
Understood. Okay.
I want to know why my no contact orders are being violated. That's where we are. Does anyone want to address that?
Your Honor, this is unfortunately not an uncommon situation that happens when you've got parties that are getting divorced. We have new paramours involved.
So was this contact made at a courthouse?
It wasn't made at a courthouse. It was not, Judge. From what my understanding is that he had gone by, and he is struggling mentally to try to let go of what this relationship was. He misses his kids. He misses his wife. Unfortunately, she's moved on. What I can tell the court is that it appears that there was an application for a protective order filed, correct? My client has agreed to the entry of that protective order. It is a 5-year protective order.
But how old is he?
Who?
How old is your client?
How old is my client?
Yeah.
I would say probably like 40, 45.
All right, so I don't understand what he doesn't understand, that the court ordered a no contact order with Scarlett Jones. I mean, I know you all have your proposed agreement, but I don't know why I should follow this. I ordered no contact with Scarlett Jones. All of this nonsense about people not being able to let go. You can cry, when nobody's around, ask the gods, why am I not with this person? But I told him he couldn't be with her anymore.
Judge, I understand that, and I fully respect your position. Sometimes emotions get better at people, and I'm not saying that's an excuse, but I think that's the reality of what happened. Nobody was harmed. Nobody was, I don't believe in it. Nothing happened from the contact. I'm trying to get this guy back on track.
Yeah, but this is what I want you to understand where I'm coming from. I ordered no contact with Scarlett Jones. I ordered no contact with Sydney Jones. This is an assault family second offense, and we probably wouldn't be here, and maybe you would still be in a relationship with them if we were not here for an assault family second offense. So I don't know why people tend to cause problems in relationships and then are shocked when somebody moves on and they don't want you anymore. So I don't know why I should follow your agreement when the main thing the court ordered was no contact. And this is a family violence case. And people don't want people showing up to their door because they've moved on and they don't want you anymore. I don't understand why people don't understand when people don't want to be with you anymore. It's like, I'm over, I'm done. I don't want you anymore. Why can't people internalize that?
I think he has. I think this time in jail has helped him do that. And Judge, if I had a reason for you to follow this, it would be to provide him the assistance that he needs to try and reform himself. I think the battery intervention program alone will do wonders for him. It will open his eyes as to what's going on here. And I also think that, like we said, he's been in jail for about 60 days now. He's going to have another 30 on house arrest. He's going to be on GPS. We can not only monitor him and protect the family, but he's got a protective order in place. I've already explained that to him, and this is for the record. I've explained to him that protective orders have teeth, and that if he violates that, it's not just an MTR next time. He's going to be back in here on a violation of a protective order.
Oh, but my rulings have teeth, and my ruling was
absolutely
there's to be no contact. What has he done on probation other than, get all caught up in his feelings going to somebody's house who doesn't want him anymore? Did he do anger management? Did you do anger
I
management?
enrolled in the PIP. I did 5 classes of the PIP so far.
Probation, has he done anything?
Judge, he was granted probation in November. He submitted a negative delay in December. I don't have any indication that any of his classes have been complete. He did a a total of $190 for his assessed fines and fees.
All right. Is there anything else?
No, Your Honor, and if the court would like to as well, like I said, not a state's file, like me creating a separate thing in a different file chart. I had to like draft out the relationships. It's like a whole page of who interacts with who. So if the court, if I could better explain, I would. I have that information. I don't have it with me. It wasn't.
Oh, no problem. The information I have is I ordered that he was not to have contact with Scarlett Jones. He's saying this is the love of his life. This is somebody he's willing to go to prison for, obviously, because he can't let her go. So I ordered no contact. This is an assault family second. He probably would still be in a relationship with her agreeing to be in a relationship with him if this wasn't an assault family second.
Judge, I understand completely where the court's coming from. I think that my client has had some time to, for lack of a better word, get it together. And I think that he can be successful in this. It's his first MTR. I'd ask the court, please, just allow him to complete these conditions. It's zero tolerance. Explain it to him. And if he comes back.
All right. The court is finding violation of condition number 19 true. The court is going to find him guilty. There's an affirmative finding of family violence. The court is not going to grant him probation. Would anybody wish to speak to punishment?
Your Honor, I understand the court's ruling. I think that given the facts and circumstances here, and the fact that there's a protective order in place, and my client agreed to that protective order, he has moved on. I think that there is not any imminent danger to Ms. Jones or his family, and I don't see him going by there at all. We would ask, I know the court's got the full range of punishment. The court's not considering probation. We would ask for a minimum on this, a minimum of 2 years. This is not something where on this violation, anybody else was hurt. There's no other violence. And we just ask the court to consider the minimum on this case.
State.
And then, Your Honor, the state, about 10 seconds, Your Honor, the state is accessing the legacy system just to get a better handle on the Bexar County criminal history, Your Honor. The state would respectfully request something in the range of about 4 years, Your Honor, and that is the state's recommendation.
All right. Court is going to find you guilty. There's an affirmative finding of family violence. Give you credit for any time served. There's to be no contact with Sydney Jones or Scarlett Jones. Court will sentence you to 4 years in the prison. All right. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and signed it?
Yes, ma'am.
All right. Do you have a limited right to appeal? And that right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Because this is an affirmative finding of family violence, and also because this is a felony conviction.
Here's where Judge Boyd really shows his depth, catching a crucial legal detail about ancestry that could completely change the CPS process. That one observation, it could activate federal protections under the Indian Child Welfare Act. Few judges spot that in time, but Judge Boyd isn't just closing a case. He's safeguarding someone's rights before they even realize what's at stake.
Or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand? All right, we can go off the record. I want you to know I listened to the arguments of your counsel. I took that into consideration. And sometimes when the prison sentence that I give people think, oh, she's just doing that because the state requested it. There are different things that I'm thinking of in my mind to see what's an appropriate sentence for you. Do I think you deserve the full 10 years for contacting her when what your counsel has told me there was no violence perpetrated? No. So I wasn't going to send you to 10 years, but I don't think 2 years was appropriate for you either. You understand? All right. Court is calling NIMAG number 758930, State of Texas versus Marlon Daniels. Can I have parties announced for the record for the state?
Jason Gary, hand on.
Defense?
George Sherman on behalf of the defendant.
And are you Marlon Daniels?
ma'am.
All right, defense has filed a motion for release of personal property. State, have you a chance to review that?
I reviewed it last week, yeah.
All right, any objections?
Yes, Your Honor. At this time, it's just, in just abundance of caution, the state has not reviewed the possible items that would be returned. I know that there's some identifying papers, and there's other objects that we may not be opposed to necessarily. I believe Mr. Sharman said something about a scooter of some sort for
All right.
getting around.
Let me go through the list and you just tell me what you have objections to, then I'll hear it. All right, his wallet.
Objection.
All right, and what is the state's objections to him receiving his wallet back?
Identification purposes, Your Honor, for him being in the vehicle.
All right, so is it possible for parties to make a copy of the items that are in the wallet, make a copy of his driver's license, make a copy of the VA documents, have the defendant and defense sign off to the fact that these are copies of the wallet, the driver's license, and the VA documents that were in the vehicle?
I'd be fine with that, Judge,
Yes, that's fine with the state. Your Honor.
All right.
as long as we can do it soon.
Well, that's something you all have to work out
Okay.
amongst each other. So the wallet, the driver's license, and the VA documents will be returned once the state has made copies of those. Mr. Daniels, can you raise your right hand for me? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do, ma'am.
You can lower your hand.
Thank you.
So you understand the wallet, the driver's license, and the VA documents will be returned to you once the state is able to make copies of those documents?
Yes, ma'am.
And you understand that your attorney has agreed that you will sign a document stating that the copies the state will make of the wallet, the driver's license, and the VA documents. You will sign a document stating that those documents, the originals, came from the vehicle, whatever part of the vehicle, and that you agree that they will have been found in that specific place.
Yes, ma'am.
All right. Personal documents.
I don't know what the personal documents are. Your Honor.
Badge that you.
What are the personal documents?
Garage door opener, key card for work.
All right, just one second. Let's slow it down.
Right now.
So the garage door opener,
Key card for work.
key card for work,
And there's a gym bag and it has a miscellaneous items in it.
gym bag. Well, here's the thing. We have to be very specific.
Okay.
What's in the gym bag?
Probably pencils, pen, an air pump.
All right. So with regards to the gym bag, the court is not going to agree to release that to you until people have had a chance to view what's in the gym bag.
Okay.
All right. Garage door opener. Any objections? Okay. Key card from work.
Maybe just a copy of it, Judge. I don't know if it has a photo ID or anything.
All right. So the key card from work.
It doesn't have photo ID. Remember, it's just a regular,
All right. So what we'll do is the state will make a copy. Both defense and you will agree that that is a copy of the original that came from the vehicle. All right. So those will be released. Air pump.
So for basketball or some sort.
What is the air pump?
the air pump was basically for when I have flat tires, emergency purposes.
No objections to that.
Okay. Clothing.
I had two jackets, winter jackets, one hoodie, they're both hoodies. One's a zip up hoodie.
Winter jacket and hoodie. State, is that an item that you all can have somebody take photos of?
That's what I was going to suggest, Your Honor. Just we can take photos of those items.
All right, so they're going to take photos of those items. And again, counsel, and you will stipulate that those items were found in the vehicle?
No problem, man.
Okay.
Sorry.
Documentation from glove box.
I believe it's an owner manual. Might be a measuring tape, tire gauge, maybe registration and license, not license, but insurance paperwork. Can't think of anything else that might be in there.
All right, the owner manual.
We'd like that to stay with the vehicle. vehicle.
All right, so the manual is going to stay with the vehicle because really what can you do with an owner manual if you don't have the vehicle? With regards to the measuring tape,
No objection.
okay. Tire gauge,
No objection.
registration, insurance, and paperwork copies.
We'd like to at least keep that with the court, I'm sorry, with the vehicle, or at least make copies.
All right. So with that, there will be copies. Sir, are you okay?
Just breathing right now, ma'am.
Okay. Do you need to have a seat?
I think I'll be fine.
Just 1 second. Deputy Laura, we're going to get him a seat.
There he is.
All right. Yes. Let him have, sir, have a seat.
Thank you.
And just take deep breaths. Do we need to call somebody for you?
No, I should be fine, ma'am. Just hyperventilating.
All right. Do you need any water?
Yes, please.
I thought I had a bottle.
Quiet down, please, we're on record.
Could somebody see, do we have cups in the back to get him some water? All right. Thank you.
I'll get some for you, sure.
And then state, do you have any objections to the scooter from the trunk?
Is that this is scooter like
It's,
for injured legs?
Yes.
Okay. No objection to that. No.
All right.
Again, I'm sorry, just to take photos of it.
Okay.
I believe there might be photos, but I have not reviewed that to make sure.
All right. So this is the court's rulings. With regards to the wallet and the contents of the wallet, this and the driver's license, the VA documents, the state is going to take photos. Both defense and Mr. Daniels are going to stipulate that those are copies of the original, and you're going to stipulate to the location it was found in the vehicle. The air pump, the state has no objections. 2 jackets, the state will take photographs of those. Mr. Daniels in defense, you will stipulate that those are items that were found in the vehicle and the location of it. Documentation, the owner manual, that will be denied. Measuring tape, the tire gauge, state if you want to take photos of those and then give them.
Yes, Sean.
The registration insurance paperwork, the state will make copies of those. Both the defense and Mr. Daniels will stipulate that the copies are the originals and to the location where they were found. Scooter from the trunk of the vehicle, state will take photos, and both defense and Mr. Daniel will stipulate that those are photographs of the originals and where they were found. Is there anything else from either side?
Nothing from the state, Ron.
No, ma'am.
Anything else?
No.
Any other items?
If there is, I can't recall, ma'am.
All right. So, and counsel, if you all want to make arrangements for you and maybe the investigator or somebody to go view the vehicle, and if there's some items that is not on the list here, you can always come back to the court.
I have it in there.
Okay.
I spoke to him last week, so.
All right. So I'll make notations of this, and then we'll have your client here so he can catch his breath.
Okay.
And they're going to bring him on.
Hi, Judge. So a supplemental report was submitted to the court. Well, it wasn't submitted to the court. I held on to it to notify the court that Mr. Warrington did get evaluated for felony drug court. However, he was rejected because according to the documentation, he felt like he didn't need to be in felony drug court at the time. He's been in sobriety for quite some time at this point. He's been incarcerated since October of 2023. And he feels like possibly outpatient treatment would work for him. He was.
So are you saying that he wasn't accepted because he felt like he didn't need it?
It says, may I?
Yes. All right.
Can I finish?
Yes, you can.
So during his TAP evaluation that was in April, it recommended him to be evaluated for DDRF. Well, when he went on to further evaluation for DDRF, they rejected him, saying he did not need the treatment, but he would benefit from outpatient treatment and being on the the mixed caseload, the mental health caseload. The original conditions of probation indicate that you did want him to be referred to felony drug court.
Mhm.
It also indicated that you would consider, or it was a term that he participated in dual diagnosis outpatient program.
Mhm.
So I just wanted to make the court, remind the court of that.
Okay. So here's my question. Why, when I send people to places, they act as though they don't have a problem with that? That's my question. So here's the thing. And I want you to hear me very clearly. You say you don't need felony drug court. Guess what's going to end up happening? If you test positive one time, I'm telling them to file a motion to revoke. And I'm going to make a notation on here that you said you did not need felony drug court. So they're going to file a motion to revoke if you test positive. Do you understand?
Yes, ma'am.
Probation.
Your Honor, so would the original conditions already indicate dual diagnosis outpatient program as well as the mid caseload. So at this point, would you consider releasing him from Bear County Jail to continue with the terms of probation?
Where is he going to be living?
1033 Burlington.
No. Who are you living with?
Oh, that's right, Louise.
Who is she?
So, she's a very good friend that I met when I first moved to San Antonio. And she has a place. She said I can come stay with her. No, no, I have no contact with her whatsoever at all, period. None.
No. Here's the thing. She's the person you had contact when you first moved to San Antonio. Is this a person who knew about your drug issues?
No. So when I didn't take my issues at home. I never got high at home. When I did get high, I didn't get high at home. And when I did, get high, it was due to the fact of a situation had happened. And I felt like I didn't want to sleep anymore. Just like I had told him in my mental health, I felt like I didn't want to sleep anymore. That was the only way I knew that I didn't have to sleep. Because I woke up to find my girlfriend, found her dead. So it was like, it was a serious issue right there. Other than that, I had stayed clean. I had been out of TDC for 20 months, stayed clean. Had a little side job. It wasn't a real job, but it was something that was getting me by.
And how did your girlfriend die?
She was murdered.
Right next to you?
No, I was under the bridge. Ooh, I was under the bridge with her because she was home, but she couldn't go to my sister didn't like her. My sister thought she wasn't no good for me.
Okay.
So she can't come to the house, blah, blah, blah. I'm like, all right, well, I went to go see her one morning and I, fell asleep at her spot. Well, she left and came back and went in the back and I was woke up by a guy telling me I'm going to go back here and shoot this chick, but I didn't know she was back in the back. Heard the gunshot, went back to sleep, woke up, and when I went around, she was dead. This was in, I want to say the first week of September, right before I had gotten arrested. You know what I'm saying?
Mm-hmm.
So, and it was like, when I seen it, I'm like, man, no, this can't be. I'm like, why'd you do this? So I felt like, look, I can't go to sleep no more. I don't want to sleep. Like, the only person that I could talk to really at that point in time, you know what I'm saying, was gone. You know what I mean? And the dude that did it got away with it. So, like I said, I was clean. I know what it takes to stay clean. I have what it takes to stay clean.
All right. Probation.
When
Do you
you-
want him at felony drug court? Because they will address the mental health issues. They'll address the drug issues. I don't even know this person he's saying that he's going to live with. I don't think anybody knows the person he's going to live with.
Judge, another original condition of his was to participate in sober support meetings daily.
Mhm.
I don't know if it was for 90 days or 120 days.
120.
On the referral for felony drug court, another class was indicated that he could possibly benefit from. Other than that, maybe we can see about lifetime.
Okay.
If he's saying that from what he's told you today, maybe with those resources we'll be successful.
All right. I'll alternate conditions for lifetime recovery and the recovery and motion program. And if he tests positive, file an MTR.
Yes, Judge.
Is there anything else?
I'm gonna try to figure like what is, okay,
I'll explain.
okay, okay.
All right.
All right.
Thank you. You're welcome.